Good morning, everybody, and welcome to our peopleHUB session for today. Very warm welcome to everybody that's attending. If you're here for the first time, I hope you enjoyed the session. This is a monthly webinar that we hold as part of our peopleHUB community. My name is Victoria Brown. I am the chair of peopleHUB. And I'd also like to thank 1HR who sponsors this event to ensure that this remains complimentary to people to attend. So before I say anything else, I just want to say well done for turning up to this session today to attend a 45-minute session around employment law changes on Thursday morning. I think you need to give yourself a pat on the back already. It demonstrates clearly that you are very invested in your people. So before I hand over to our speaker today, I'd just like to ask you to look at your screen now. You have, we use Slido, so by all means you can add questions into the chat box on Zoom. If you're not using your phone to watch this webinar now, then what I'd ask you to do is just take a picture, I'm going to do it with you, of the QR code, click on the link to Slido. Mine's not playing today. Hopefully everyone else's is. Click on the link to Slido, and then that is where you can ask all of your questions. It is anonymous, so you can ask as many questions as you want to. And what we'll do at the end of the session is we'll just put them up on the screen, and obviously the ones that are the most popular and ask the most, we'll start with them. So, but as I say, please do feel free to pop anything in the chat box as well. We will monitor that as well. So I'd like to introduce you to Kendal Hulme. Kendal Hulme is the head of operations at HPC. She is a very seasoned HR consultant with lots of experience under her belt. So she is going to talk us through the changes. We are going to share the slides. Obviously, there's quite a lot of information. The flurry of employment law changes is unbelievable this year. It's like they've just stored them all up and thrown them all out this year. There's quite a lot coming up in April, and there's quite a lot to come at the end of the year. So there's a lot of information. So don't worry about trying to take too many notes. We will share the presentation afterwards. And if there are questions that spring to mind after the event, please do not hesitate to contact, and we'll forward that information to you. We will also send you a recording of the webinar as well. So just take in what you can now. So Kendal, thank you so much for attending today. I'm going to hand over to you now, and I'll go on mute.
Good morning, everyone. It's great to see so many people attended. I think the high attendance is probably something more to do with the fact that there are so many changes rather than it being me as a guest speaker, but I can pretend. Like Vic said, I work for High Performance Consultancy, head of operations at the moment. I'm also a consultant, so I'm in the thick of all things HR every day. In my previous life, I was the HR director for a group of companies covering varying sectors. So I've kind of dipped my toe into many of an industry, and there's a lot today that we're going to cover that will affect pretty much all sectors. So like Vic said, just to mention, you can submit the questions through Slido. I think I've got the option, I can possibly view the chat as well. So if anything does pop up, I might mention it as we go along. And it would be great to hear some of your views on some of these changes as well. And if we don't cover anything, then like Vic said, Vic can share my details and we'll go through it afterwards. So what are we going to cover today? There's so much to go through. 2024 is having a serious overhaul in employment law. Some of what we'll cover today, I'm sure you will agree, is well overdue, whereas other parts of legislation I found quite surprising, but we'll go through all of that and keen to know your thoughts on it. So we'll cover the confirmed, expected, and some potential changes for the rest of the year and further on. We'll look at what employers need to do as HR, as an employer, and of course, how HPC can help. So if you just move on to slide 2 for me, please, Daniel. Right, this one isn't actually that exciting or as gripping as some of the others might be, so just bear with me on this one. This one's about the retained EU Law Revocation and Reform Act 2023, which is in place since January 1st of this year. So the act is known as REUL, which I'll let you pronounce that as you will, but REUL I'll go for today. It grants government ministers new powers to alter EU-based laws, which essentially means that we're no longer bound by EU law. So anything originally derived through EU case law will be lost. The Act is also encouraging the Court of Appeal, Supreme Court, to make use of their existing powers to overturn EU-based case law. What does that mean? It means that EU law will no longer automatically take precedence over UK law. So there's a lot more control and power in UK law to change some of these laws, which may come as a good thing or a bad thing, depending on the industry that you're in. So in the short term, there's no major changes to employment law, but longer term, we definitely can expect to see plenty of reforms in the legislation. I think this is most likely going to be influenced by the next general election. So it's a case of now, watch this space. Let's see how the regulations such as working time regulations, TUPE, they're going to evolve. And we will, of course, we can keep our clients up to date. But you as employers who aren't part of HBC's client base, you need to be making sure that you're keeping on top of any announcements and changes that come through as a result of this. And also, you can sign up to newsletters, articles, keep yourself on top of it. And most likely it's going to mean that there'll be a lot of policy changes coming up for the HR departments within your businesses, you know, because we haven't had enough to do so far this year. So can we move on to the next one, please, Dan? You can go. Right, we're going to talk, the next few slides are about immigration and visas. Appreciate that not all of you on this webinar will deal with sponsorships and necessarily visas, but it's still really important that you understand the implications of these changes. The current government has focused on reducing net migration and it introduced some significant changes to visas and immigration this year. There's been a huge increase to the immigration health surcharge, its purpose being to ensure that migrants continue to contribute to the cost of healthcare provided by the NHS. So when individuals apply for most types of visas, they'll have to pay an upfront cost alongside their application. And this payment entitles them to full access to the NHS services during their stay in the UK. So this has come in since the 6th of February. The increase is 66%. The full rate was originally £624, but we're now at £1,035 per year that they will have to contribute to the immigration health surcharge. And the discounted rate, which typically applies to children, students, youth mobility visas, was £470 and is now a whopping £776. So you can see the massive impact this will have on households that have, say, two people in them that are on visas and also have brought with them children and students. There's thousands a year that they'll be needing to contribute. This was justified by the Home Office based on calculations relating to the NHS migrant cost factor. So this factor contributed to the IHS rising more rapidly than the NHS budget. The increase aligns with the 2019 manifesto commitment to ensure that the health charge reflects the full cost of the NHS treating health charge payers. So in summary, the increase aims to maintain fairness and financial sustainability while providing essential healthcare services to migrants in the UK. And Daniel, next one, please. So we've also got, staying with immigration, the UK government has also introduced a 5-point plan to significantly reduce net migration, which apparently, according to the government, reached a record high last year. So the key measures in this 5-point plan, we've got a ban on care workers bringing family dependents. That's in place now. That came in place on the 11th of March, so a few days ago. Care workers are now no longer allowed to bring their family dependents to the UK. They've argued that this measure seeks to regulate the entry of care workers and maintain a focus on essential healthcare roles. So given that that care workers are a significant number of the workers entering the UK, and the NHS and the health and social care sector really do rely on them so heavily, I think it's going to be quite interesting to see how this affects recruitment in this sector. I worked in health and social care for 10 years and recruitment was always a massive issue. So I'm not sure how this will pan out. Would be keen to obviously hear people's views if you've got any comments on it. Love to have a conversation about it and see how this is going to impact your sector. Absolutely. So the next one is a minimum salary increase for skilled overseas workers, which sent all of our clients into absolute panic, the ones that sponsor, because it is such a significant increase of the minimum salary required for skilled overseas workers. It's gone from £26,200 a year to a minimum salary of £38,700. Quite a dramatic increase. And as I said, I think quite a lot of my clients have had a few negative things to say about it. Whilst they understand the purpose behind it, it's going to have a huge impact on employers that do sponsor workers. So this does not only apply to, this only applies to new entrants. So anyone that is already sponsored isn't affected as of yet. So this will be new entrants into the UK on these skilled worker visas from 4th of April. They're also going to end the 20% going rate on the shortage occupation lists. So as it stands, if your job is on that list, the sponsored worker can be paid just 80% of the usual going rate for that role. So the government is seeking to just remove that completely, and they will have to pay the going rate for the role that are on the shortage occupation list. Minimum income requirements for visas. So as with the minimum salary requirement, they're aiming for 38,700 to be the income for family visas. And this has gone up from £18,600. They are going to do it in a staggered approach. So the first increase is on the 11th of April. That's going to go to £29,000. It'll be going to around 34.5 later in 2024, and finally to around the 38,700 mark by early 2025, it is anticipated. So we need to keep a close eye on those dates and where it's relevant for your work. So the idea behind this is this ensures that family visa applicants meet a higher income threshold, and so that they're able to contribute more to the government. There'll also be a review of the graduate visa route. So this is the one, this is the 5th of the 5-point plan. The government's migration advisor will review the graduate visa route to prevent misuse. So this could mean that graduates who currently can work without the need to be sponsored would not be able to bring dependents on their graduate visas. This step, again, is aiming to enhance the integrity of the visa system. So some big changes in this 5-point plan that we need to stay on top of. We need to make sure that we are following all of the rules that have been set in place. Can you move to the next one and final one on immigration for me, Dan? Thank you. Right, so finally on immigration, this is something that I cannot stress enough to our clients: right to work checks. From the 13th of February 2024, should you employ someone without carrying out a right to work check and they're an illegal worker, you can now face a penalty that was £15,000, which was still an awful lot of money, is now £45,000 per illegal worker for a first breach. And that is now going up to £60,000 from £20,000 for repeated breaches. I mean, this is enough to close businesses with just one illegal worker. God forbid if there are multiple that have been found to have been employed. And this will 9 times out of 10 be failure to have completed a right to work check. So not only do you face fines, but there will also be custodial sentences potentially. So completing your right to work checks are so important. We have guidance on right to work checks. We have a whole suite of documents on how to do this. We guide our clients through this, and it is your obligation as well to complete your due diligence through recruitment. So every single employee, regardless of whether you've known them for 20 years or you know someone that's known them for 20 years and believe that they have the right to work in the UK, you still have to do their right to work check regardless. We can also help with updating your policies, but that's absolutely something that you as HR professionals out there, business owners, if you don't have an HR provider, you have to be updating your policies as well and your guidance. And I would recommend always doing an audit to double check that you do have those right to work checks in place. HPC can also help with potentially dealing with an audit when you've found that you might have somebody that doesn't have a right to work check, what to do next. It's quite an overwhelming situation to be in for clients. that we found. So as business owners, it's something I would definitely recommend that you look into. I think next one, please, Daniel. Oh, holiday pay. Right. Holiday pay rules, calculations, entitlement, everybody's favourite topic. If you do have any specific calculations or queries on this, please feel free to add these to Slido and we will come back to you on them, because I appreciate this is an absolute minefield for an awful lot of people. It's something that certainly since the Harper Trust Brazel case has caused many a headache. So if you do have any queries, please just send them through. We're happy to help you at the end. So background to this, we do have this infamous Harper Trust versus Brazel case, and which resulted in the government consulting on overturning the ruling. Thank God. So Harper versus Brazel meant that part-year workers on a permanent contract were entitled to the full 5.6 weeks holiday pay that a full-time worker would receive. So to put that into perspective, because it was quite mind-blowing at the time when this was all up in the air, it meant that in some isolated cases, an exam invigilator, for example, who may work sporadically over, say, 4 weeks a year, but was employed on that permanent contract just to do that, would be entitled to 5.6 weeks annual leave, which is more than they would have worked that year. So it needed looking at. The government stepped in, the Supreme Court threw it back to the Parliament, and thankfully here we are. So they have now given us some clearly defined definitions of irregular and part-year workers, which I'm going to read verbatim for you. An irregular hour worker, a worker is an irregular hours worker in relation to a leave year if the number of paid hours that they will work in each pay period during the term of their contract in that year is, under the terms of their contract, wholly or mostly variable. So the real key part there in your irregular hours workers is that under the terms of their contract, it is stated that it's wholly or mostly variable. So that will be, we call them variable hour contracts. And it's really important that your contracts are looked at in this respect. So a part-year worker. A worker is a part-year worker in relation to a leave year if, under the terms of their contracts, they are required to work only part of that year, and there are periods within that year, during the term of the contract, of at least a week which they are not required to work and for which they are not paid. This includes part-year workers who may have fixed hours. So, for example, there may be teaching assistants who only work term time, but are only paid for the hours that they work. So their work isn't annualized like a teacher's would be. They would be considered a part-year worker. And everything is relevant to those people right now that we're going to go through. So irregular hours and part-year workers will now have their holiday pay calculated as 12.07% of actual hours worked in a pay period for leave years starting on or after 1st of April. So in 2 weeks' time, everything's, in theory, going to be a lot easier to calculate for these workers. There's a lot of work to do in the background with your contracts, with discussing this with staff, with your payroll departments. But rather than having to go through some seriously mind-blowing calculations, we've gone back in time a little bit and they've reintroduced that 12.07%. So I think that's probably going to be quite welcomed by a lot of employers. So an example would be if somebody works 50 hours in May, to work out how much holiday they would accrue for May, you'll need to calculate 12.07% of 50 hours. So it's much easier. Carryover rules have changed now. So we've got emergency COVID rules that were put in place to allow employees to carry over annual leave, because many were obviously unable to take it during the pandemic. This has now been removed from the 1st of January. So COVID carryover will have to be taken by the 31st of March 2024. So they have 2 weeks to take anything still outstanding that they've carried over due to the pandemic. If they haven't taken it by the 31st of March 2024, it's use it or lose it situation. So my advice on that one would be, if you haven't already, you do need to notify those employees. We're on the 14th now. They've got 2 weeks to take it. Carryover for sick leave is just 4 weeks, not the 5.6, and this is limited to 18 months after the end of the leave year, in which they've accrued for the sickness absence. And carryover for statutory leave, such as maternity, remains at 5.6 weeks into the next annual year. So employees can carry over 1.6 of the 5.6 weeks if there is a contractual agreement to do so. So if their contracts of employment state that you as a business will allow them to potentially carry over 1.6 weeks of annual leave every year, then they are entitled to do that. But it's only 1.6 of the 5.6 weeks that they could do that for, and it has to be in the contract. This one does feel like we've gone back in time. Rolled up holiday pay. So for leave years beginning 1st of April, employers will now be able to cover a worker's holiday pay through including an additional amount in their pay slips, instead of paying holiday when they take the annual leave. So this again is going to be calculated on the 12.07% of hours worked. I would be very interested to hear people's thoughts on this, as historically this was outlawed. I remember when it happened. As the worry would be that people won't be taking the breaks, they won't be taking the leave from work. So it does feel like a bit of a blast from the past, but I know that there are definitely some sectors that are going to really welcome this one with open arms, such as hospitality, I would imagine. Record keeping as well is changing. So EU case law required all employers to keep records of daily working hours. They had to be recorded. Adequate records are still going to need to be required for national minimum wage purposes, and it would obviously still be responsible to keep records of your working hours for breaks, to avoid burnout, to make sure that for health and safety purposes, your staff are kind of looked after. But it's no longer a legal requirement to keep a record of working time other than for the national minimum wage purposes. So what do you need to do with all of this? There's a lot to do with annual leave. As I said, with the COVID carryover, I would recommend that you notify your staff, if you haven't already, that they're running out of time to now take it, and it will not be carried over into the next holiday year. You may have to do some redrafting of contracts, because some will reference a different way of calculating the variable hour, irregular hour, part year worker annual leave and how it's paid. That may require some consultation depending on the circumstances, which I would recommend you definitely seek advice on if your contracts are very specific. And if you want to introduce the rolled up holiday pay, which I assume a lot of businesses will do where they employ these workers, that's absolutely fine for new workers from the 1st of April 2024. But if you're wanting to introduce it for already existing staff, you are going to have to consult with them on that. Consultation is key here. Consultation if you're changing anything for your staff. So I really would recommend that you seek advice. You also will need to update policies, and of course payroll needs to be updated on absolutely everything, which I'm assuming they will be. But those of you in HR that deal with payroll, with that lovely double-edged sword you've got, you'll need to be fully understood on what's going on here. Okay, Dan, on to national minimum wage, I think. Yes, so for the first time, workers aged 21 and 22 will also be entitled to the national living wage from April 2024. Currently, it's only those that are aged 23 and over. So it's a huge impact for those that are 21 and over who reach national living wage. And it's the largest ever increase for the first time. It's ever gone more than £1. It's huge, brilliant sign for the age group. And that it's going to gradually come down, and that we might start to see some parity. So the rates are all on there. I won't bore you with going through exactly every single one, but what you need to do as an employer, obviously, if people's rates are changing, you can write to them, advise them if they're increased, changes to the age bands. We've got lots of resources that we can provide as well for this. Clearly, payroll needs to be updated, and pay slips, of course, will need to reflect all of the changes. Next one, please. So we've got statutory pay increases. There's a slight increase to weekly SSP coming in from April 6th. It's £116.75 now rather than £109.40. But the LEL, the lower earnings limit per week, is remaining at £123. So no major changes there, just a little increase for the SSP. And again, down onto the next one. And again, this is all of your kind of family-friendly payments, such as shared parental leave, SMP, SAP, SPP. They're all increasing from 172.48 to 184.03. So we what we do at HPC is we update everybody's handbooks where these rates are referenced. We make sure that all documentation is updated. You'll have forms that people will need to fill in when requesting certain leaves. So need to be on top of whether or not they need to be tweaked with these new rates that have come in. So I would really recommend that you all review your policies and your documentation before April. So on to carers leave. So brand new one, day one rights, unpaid carers leave. So this came into force, will come into force, sorry, on the 6th of April. It's a new statutory right to allow employees to take unpaid leave to provide care for a dependent who meets specific criteria. So specific criteria is a physical or mental illness or injury that requires care for more than 3 months, a disability as defined by the Equality Act, and old age resulting in care needs. There is no evidence needed for eligibility to take unpaid carers leave. So you can't ask your member of staff to prove that they look after Aunt Ethel down the road. It's a case of there is just no eligibility needed, and it's a day one right. So the term dependent is not limited just to family members. It can include anyone who relies on the employee for care. So that's even a neighbour, a friend. It doesn't have to be someone they live with. It doesn't have to be an elderly grandparent. It is anybody that is dependent on them. And they're entitled to take carers leave from the first day of their employment, like I said, and their employment rights are safeguarded during this leave. So holidays, job protection, etc. It's all protected during this leave. So the key details about unpaid carers leave, which will be covered in a brand new sparkling policy that we've created as well, but will be accessible through your own HR providers, I'm sure, if you're not with HPC. The duration, so employees can take up to 1 week of leave every 12 months. The definition of a week corresponds with their typical working week. So if, for instance, somebody works 3 days a week on average, then that's their week. That's 3 days of carers leave that they can take a year. They can choose to take the entire week, or they can use it as individual days or half days throughout the year. If they have multiple dependents, they don't get multiple weeks of carers leave. They get the 1 week in every 12 months, but they can use it to care for different dependents if needs be. Those who have irregular working patterns, the amount of carers leave that they can take is calculated on the total number of hours worked in the previous 52 weeks, 12 months. So divide that total by 52, or the number of weeks since they started, if they've not been with you the full year. This will determine the amount of leave that they can take as carers leave. Employees do need to give you notice to take this carers leave, and it's very similar to the notice given in annual leave, where it's typically double the amount. So for requests spanning multiple days, the notice period must be at least twice as long as the requested leave. So if, for example, they want to take 2 days off, they need to give you 4 days notice to take that time off, unpaid. In emergency situations, of course, employees can take the time off without prior notice, but hopefully those will be few and far between. An employer's discretion. So can you refuse to give an employee unpaid carers leave? You can't refuse, but you can request that it be taken at a different time. This is permissible only if the employee's absence would cause serious disruption to the organisation. And if you do delay it for whatever reason, because there's a serious disruption to the organisation, then the employer must agree on a new date within 1 month of the requested date and provide written notice to the employee. So quite a few little nitty-gritty bits on unpaid carers leave. But as I said, this is going to be a brand new sparkling policy that, yes, another one that we'll be sending out to all of our clients. Your HR providers will also be doing for you, I'm sure. In-house HR, you will need to obviously seek out and draft your own. but this will also probably need adding to handbooks as well if you reference in the handbooks family-friendly policies. And your management, anybody responsible for approving any leave like this needs to be fully aware and fully trained on this. I mean, really, you could, I guess you can share this webinar with them because there's a recording, isn't there, that's going out. But so it's about educating the workforce on all of these changes because there just really are so many. Right, paternity, please. Thanks, Dan. Right, the paternity leave amendment regulations will come into force from the 8th of March, so 1 week ago, and will be relevant to those where the expected week of childbirth, which is the EWC, is on or after the 6th of April 2024. So these regulations are trying to kind of support fathers in balancing work and family responsibilities. And in my perspective, I think it's a great move. It's quite outdated, the old system. So I'm all for this change. So the key details are employees can now separate their leave into 1 week blocks rather than 2 weeks in one go. So before they had to take it 2 weeks consecutively, now they can have 1 week in January, 1 week in May. They can also take this leave as well anytime now within the first 52 weeks after the birth or adoption of the child, which was originally within 56 days of the birth. So it's given them a lot more scope of how and when they can take this paternity leave. They also now only need to give 28 days notice rather than 15 weeks of their entitlement to take paternity leave. And if they need to change it for whatever reason, again, they only need to give 28 days notice of that change. So like I said, I think this personally is great. It's adding more flexibility. It's going to help balance that work-life balance, and through these key, really important stages of people's lives, a little bit of flexibility goes a long way, I think. But again, a lot of work for us in HR. So it's all about updating the policies. Your shared parental leave policy is probably going to need to change as well, because that likely does reference the paternity in there. And your handbooks or the forms relating to paternity leave, they will also need to be updated. And again, like with the other changes that we've seen, flexible working, carers leave, we need to make sure that management is properly trained on this. So now we have enhanced pregnancy redundancy protection. So this is enforced from the 6th of April. These provisions are aiming to provide a greater support and fairness for employees during significant life events. So you can see a real shift in the mindset of the government and legislation at the moment. Everything is really focusing on employees' fairness, flexibility. So these changes will now enhance the protection for 18 months after birth, but will begin from the moment the employee tells the employer that they are pregnant. So these additional protections, you've got pregnant employees who are at risk of redundancy will have priority for any suitable alternative vacancy that is available from the point that they notify the employer of their pregnancy. Employees returning from maternity leave, adoption or shared parental leave who are at risk of redundancy will have priority for any suitable alternative vacancy that is available. So this was already in place for those that were on maternity leave, but it's now also is relevant for those from the day they tell you they are pregnant. Employees returning from maternity or adoption leave will be protected for 6 months after their return to work, but the protected period may be different for shared parental leave. So we need to take that into consideration, because it's sometimes taken in discontinuous blocks, shared parental leave. If you do have any specific queries on that, please do send them over and I can pick them back up at a later date with you. So employees will have the right to an automatic unfair dismissal claim as well, where an employer fails to comply with its obligations regarding offering suitable alternative vacancies and the employee is dismissed. So again, policies, policies, policies. If you do have reference to these enhanced protections in your redundancy policies, in your maternity family-friendly policies, this will need to be updated. And guidance absolutely needs to be sought when you're considering any redundancy at all in your business. I'm moving on quite quickly through these because I'm just conscious we're at 10 to, and you've listened to me talk for an awful long time. The flexible working one, huge change. Again, great one for employees. I don't know how you feel about it as business owners and potentially HR, but I think great for employees. Changes again, they're enhancing access to flexible working options. You've got the option of part-time working, home working, hybrid working, flexi time, job sharing, compressed hours, annualized hours, loads of different options that should be considered. And the update is now allowing this to be a day one right for all staff. So they no longer need to have been with you for 26 weeks to place a request. They have a day one right to be able to, and they can now place 2 requests a year rather than just 1. There has to be consultation as well before refusal. Now, when me and the team read that, we thought, well, we would always advise consultation anyway, but for those of you that don't, you now have to consult before you refuse. And in that consultation, you'd be exploring alternative options, potentially compromising, and really exploring why you're refusing. So an employer now has 2 months to deal with the request rather than 3. So it's giving you a bit of a nudge to get it done quicker. And another key change, which is quite an interesting one, is that employers don't have to consider the business impact in request. So in all of our previous forms, it would say, what impact do you think this is going to have on the business? That's now gone. They don't have to think about that. This is about them. You're likely to see a lot of influx in requests when this does come into play. And it's really important then, you know, that your management teams, your HR departments, you as employers, you're all fully informed on these changes, so that your documents and your guidance is all up to date as well. Really important when considering rejecting any kind of flexible working request, that there is no element of discrimination in your decision-making process. They might not have to think about the impact on the business, but you as a business do need to consider the impact on the employee. So really important to understand that there is a difference between a reasonable adjustment as well and a flexible working request. And here we go again, more policies, more documents to update, more management to educate. We actually do offer training to a lot of our clients on this, because especially this year, it's just so much to take in. So I think that's definitely something you should all explore with your own HR providers or externally, internally. And again, you've got the recording of this webinar, so please feel free to share me talking to them. Next one is allocation of tips and gratuities. So hospitality, you'll be interested in this one. Set to come into force not until July the 1st, but once it's implemented, it's going to introduce a new legal requirement for businesses regarding the allocation of and payment of certain tips, gratuities, and service charges to their workers. So fundamentally, it is illegal for employers to keep tips and not allocate and distribute them to the employees. Going to be some key changes and obligations that you're going to have to adhere to, such as being fair and transparent. So this businesses must allocate qualifying tips, gratuities, and service charges to workers in a fair and transparent manner. What does that mean? That means you have to have, here we go again, another policy. You're going to have a written, detailed policy on how these tips are going to be allocated. And you need to have records of all of the distributed tips as well, and they should be maintained, and you will have to provide them to workers if they request them. Payments need to be made in a timely manner. So qualifying tips must be paid to workers within 1 month of the end of the month in which they were received. Now, I don't know how your businesses work and whether you pay these quarterly or monthly or whatnot, but you now will be governed by qualifying tips must be paid to workers within 1 month at the end of the month in which they were received. Employees can now make tribunal claims as well regarding this. And there will be a statutory code of practice which will define overarching principles for fairness related to the new rules. So businesses are going to need to consider this code when they're designing the policies and processes to comply with the new obligations, and failure to consider the code may be taken into account in an employment tribunal, which is similar to the ACAS codes of practice that we follow in HR. So what do you need to do? I'm told in the hospitality industry that trunk systems are integral in managing the tips. So if you don't use one, it's recommended that you definitely do. I've never personally worked with these systems, but I've told that they're absolutely a must. This detailed policy does need to be in place, and it needs to consider all of the code of practice for allocating tips, and it needs to be accessible for your staff. And I would say definitely seek advice where needed. Moving on swiftly to mental health, the HSE announcement we've had recently. I've lost Dan. Thank you, Dan. Right, so the HSE have made a huge update to their health and safety regulations concerning mental health in the workplace. The update includes an emphasis on employers' responsibility to take account of employees' mental health in their first aid needs assessment. So this has emphasised the importance of having mental health first aiders. So first aiders who are trained in mental health and wellbeing, not just physical health. So we're not just looking here about first aid for cuts, scratches, slips, trips and falls. We're looking at mental health first aiders who people in the business trained to identify and understand mental ill health symptoms, and who are able to support someone who is experiencing a mental health issue. Health and safety and HR absolutely need to work together on this. Risk assessments need to now consider mental health in them. It is not just the physical, it is all about mental health as well and well-being. And I think there's going to be a lot more focus pushed on that over the next 12 months. I know it's definitely something that Vic's really passionate about as well. Right, I'll do this next one, the last one, Dan. New duty on employers to prevent sexual harassment. So this is likely to come into force in 2024, but we're just going to briefly touch on it now because we are running out of time. The amendment now places the duty on employers to take reasonable steps to prevent sexual harassment of their employees. So this isn't just about dealing with it when it arises. We have to show as employers that we are taking serious, reasonable steps to prevent harassment happening. There is a potential uplift as well in tribunal claims of compensation of up to 25% if reasonable steps are found to not have been taken. So employees will also be able to complain directly to the EHRC, which is the Equality and Human Rights Commission, if they have been sexually harassed. So I won't go into that one in too much more detail, because I think if Vic will have me, we'll probably pop back in 3 to 6 months for the next round of 2024 updates. There's still an awful lot more in the pipeline that hasn't been confirmed, but we've probably bombarded you enough today on all of the information that we've given you so far. When you get these slides, you'll also see, and I'm going to skip through these now because we've got 2 minutes left, but on the next 2 slides, Dan, there is these are just a snippet of what's to come throughout the next part of the year. And we will definitely keep you up to date on all of our clients, and I'm sure that we'll do another peopleHUB on the rest of them. And that's all from me. Thank you very much for your time.
Thanks so much, Kendal. I think if we were in a room together, we'd give you a massive round of applause, because that was so much that you needed to go through. And I don't know, I certainly found that you, have a coffee. Well done. We need to put alcohol in that for you.
Yeah, I'll sneak a bit of Bailey's in later.
Yeah, we probably need to do that for everyone else as well. So everyone else may feel like they need to lie down now, because there's a lot of work to be done. I'm sure if you are in the room and a HR professional, you've already done quite a lot of this already. But I think the key message today is obviously to make those changes, but not just to make those changes, but that communication. And I think that a lot of the time when changes come through is where it goes wrong, because it doesn't get filtered down to line managers. It's just a change in policy, and that's not enough for these changes. So I am conscious of time. I think it's really important that we just let you sort of get through all of that. We'd love to have you back, so we'll definitely do another session. Quite a lot, obviously, of other sort of forthcoming changes, and we can also maybe do a little recap on these and how these are sort of landed within the organisation. We do have quite a few questions. I've looked through quite a lot of them as we've been going along. Some of them are statements, which is quite good. People saying that they're relieved about the roll up of holiday pay, looking really glad that there's obviously the paternity changes. We are going to have to close now because it finishes at 10. So what I'm going to suggest we do is take these questions, and Kendal, if you're happy to respond to them, and then we'll share them with the room.
And if anybody's got any more, I think if they've got details through peopleHUB, I'm happy to help.
That's fantastic. Thank you very much. So just to finish now, our next, if you can save the date, our next peopleHUB is going to be on Wednesday, the 8th of May. So we're just not going to have one in April because of Easter. So we thought, and obviously after the employment law update, you're going to be far too busy writing policy. So next one will be Wednesday, the 8th of May. We will send you some further details of that. It'd be great to see people attend that. We also do have you got on the screen there we are. If you would like to join the peopleHUB community, you're not a member, you are very welcome. We do just ask that you have some responsibility to look after people. So here are the QR codes. We will forward this information as well along with the slides. So I'm going to close now. Thank you so much, Kendal, for today, and thank you everybody for joining. Have a great day.
See you soon. Thank you.
Bye.